Welcome to Expert Views on Alternative Dispute Resolution, a podcast about simplifying ADR in a bid to attract more users to settle their disputes or conflicts with these alternatives: mediation, arbitration, negotiation, conciliation, and early neutral evaluation. My name is DrChinweEgbunike-Umegbolu, postdoctoral fellow at the University of Brighton, United Kingdom. I'm excited to welcome Professor Offornze Amucheazi to the show. He is the Commissioner of Lands in Anambra State and the founding partner of Amucheazi Ozioko Co Legal Practitioners and Arbitrators. He is a senior advocate of Nigeria with 30 years of experience in arbitration, labor law, industrial relations, and constitutional review. These experiences include legal advisory for the World Bank Group, the Nigerian National Assembly and Senate, and lecturing at the Nnamdi Azikiwe University and University of Nigeria, where he taught me legal methods. He is a published author covering several articles on commercial and business law, focused on arbitration, foreign direct investment, FDI, and labor and industrial relations. Prof wears many hats, so I've left the link to his profile below. Thank you so very much for coming on the show, Prof.
Thank you, Chinwe. Good morning. Happy New Year.
Wish you the same. All right. Okay, so without wasting much of your time, so question one is, from your experience, because I know you've practiced in different jurisdictions, how far has ADR been able to enhance access to justice in Nigeria?
Yeah, thank you very much. I think one can safely say that ADR is beginning to, as the way I put it, beginning to enhance access to justice in Nigeria.
Yeah.
And I can use it in states where I also practice as an example. Over the years, the awareness or the use of ADR was quite low, but I think at the moment, the awareness has grown considerably. And both litigants and lawyers have realized the importance of resolving disputes via ADR. There are a lot of disputes that should and can be resolved via ADR instead of spending all the time we spend in courts. And I think the awareness has really increased. And so I will say that, yes, ADR has enhanced access to justice in Nigeria, what's a particular reference to Enugu State as a whole. We have a long way to go. Because, of course, you are aware that it's a new phenomenon as it were in a country, albeit in the states here. And that's why there's a tendency for a pushback for people who still believe in doing things the traditional way.
Yeah.
But time goes on, I think people will begin to key into the need and importance to resolve ADR, to use ADR to resolve disputes.
All right. Oh, thank you so very much for that. So, is there any measurable difference or impact on the cost and time frame for settling disputes under ADR compared to litigation?
Yeah, I think so. Cost, yes. Time frame, yes. But you know, basically, it will depend on how you look at it. Most people see ADR as all other forms of ADR, excluding arbitration. But when it comes to arbitration, if you decide to regard arbitration as an ADR, the cost can be quite enormous. But in terms of the time frame, it's much, much faster. Of course, we know the problems we face with litigation in terms of the preliminary objections that we file, etc., and moving up the ladder to the Court of Appeal and Supreme Court and back to the High Court, as the case may be. Yes, the difference in terms of impact on cost and time frame, in my mind, is quite substantial. The problem, however, that we still face is that many practitioners now see ADR as a first step towards litigation. So that perception needs to, even for arbitration, where I've done quite some work, a lot of practitioners see it as a first step towards litigation. And then they advise their clients, oh, don't worry, once they're through, we're going to go to court to set aside the award. Of course, that's the entire process. And that's why, going back to what I said earlier on about the need for enlightenment. It's growing.
Yeah.
The awareness is growing.
Yes.
It's growing, it's growing. I'm sure in no distant time, a lot of people will begin to rely on ADR to resolve the disputes. Well, it goes by nature. That's part of our challenge.
Yeah.
And sometimes we want to prove a point to somebody, but eventually we'll get there.
Yeah.
So impact on cost, difference, impact on cost, yes,
Yeah.
time frame, yes, time frame especially. And because you save a lot of time. Yeah.
Yeah. Oh, all right. So far, so good. Yeah, we're getting there. Nigeria, because in other jurisdictions like in the UK, people are more aware, and the lawyers as well are more encouraging for disputants to utilize ADR. So
yeah, but part of the challenge we have here, and that's why awareness is growing amongst practitioners.
Yes, sir.
Especially for awareness amongst the public. Part of the challenge we face here is that there are times when you resolve a matter via ADR, and the litigant feels you haven't done anything. And it just feels, oh, why? What? I mean, how much time did you spend? And so, why should I pay you X, Y, Z, or ABC? And that's why a lot of the lawyers also insist, say, no, let's go through the whole litigation hog. It's easier to get the clients to pay your fees when you are in court. Okay. Yes, but I think as time goes on, even the litigating public is also becoming tired of unending litigation. I'll give you a simple example that is very prevalent, not just in Enugu, but all over the country. Yeah. And that has to do with recovery of premises from a tenant, residential premises or commercial premises. You still see cases that could be in court for 5, 6, 7, 8, 9, 10 years. Just recover a premises from a tenant. But way from the time I started my practice as a young lawyer, I know one of the things we did in the firm where I was all those years. Our principal would tell us then, look, and once the landlord wants his house, he has to get back his house. Yeah. So all you need to do is to negotiate with him and agree on a timeline. Or give me 1 year and then you enter a consent judgment. Of course, we don't have to go to court to get a consent judgment entered. And that was much faster than going through the whole hog of litigation and trying to prove whether you serve the requisite notices, etc., etc. So these are one of the areas. Areas where I think once we begin to explore the use of ADR, then we will also be able to decongest the courts. Because our courts are congested and our judges are really overworked. Yeah. So we can leave the courts to deal with more important matters.
Yeah. All right. So are employees or workers aware of ADR options regarding disputes or conflict that might arise at the workplace?
I would say yes. I was once at a seminar where what we discussed was the arbitration of employment disputes. And the question arose, speaking of arbitration now, whether we could arbitrate employment disputes. It also goes to ADR, as it were, depending on how we understand it. I think that the practice is that many in the workplace, a lot of employees or workers make use of ADR to attempt to resolve whatever disputes they have with their employer. Most of them go to court as a last option because you know as well as I do that wages are not particularly high in Nigeria. So most will prefer to resolve whatever disputes they have via ADR than approach the courts. It's when it becomes impossible or difficult sometimes to reason with employers who sometimes believe that they have the upper hand, that they're forced to consult a lawyer and then take the matter to court. So is that awareness there? Yes, it is there.
It is there.
And I know from my practice, a lot of, when they come to tell you their stories, they also let you know the attempts that were made at mediation, at negotiation, even sometimes going through the trade unions. You find out that it's not in all cases that trade unions rush to court immediately. No. They always want to negotiate. They want to mediate. They want to have discussions with the employers. The court is always the last option. So the awareness is there.
Yeah. Okay. Uncle, how about the private companies, private organizations? Are they aware?
Yeah, I think, yeah, everyone is aware. I think it just varies. It's inherent even in our traditional means of resolving disputes.
Yeah.
For most private companies, again, even when there are disputes, you see the workers attempt to discuss. But depending on the kind of company, for the large, what I call the large private companies, of course, these processes are embedded. But for the one-man companies, one-man businesses, where the owner is all, they can be very brash in the way they deal with their workers.
Yeah.
And somebody wakes up one morning and says, I don't like your face anymore. I leave my employment. Of course, they don't have a choice but to leave. And then you then have to go to court to ask for damages. Of course, it can be restated for obvious reasons.
Yeah.
So that's the way it is. But the awareness is there. It is there.
Okay.
Private companies, public companies, awareness is there.
Okay, thank you so very much. So to what extent are employees encouraged to use ADR to settle discrimination, harassment, or bullying in the workplace?
Well, I think that will depend on my own view on the organization. But I do know that, of course, there are matters that cannot be tolerated when it comes to sexual harassment, when it comes to bullying. But you also find out the typical Nigerian way of doing things, that even when an employee is accused of bullying a fellow employee, you also find out that school come in to try to mediate and resolve. The rather you resolve it in-house than go outside and go to the police, or than go to take up an action in court. Of course, you have to go to the police first and foremost. So I think it's quite widespread. Discrimination, well, you see cases now from industrial courts dealing with matters of discrimination or harassment in the workplace. They weren't as frequent as they are now, because before the industrial courts became a court of record, and it was difficult getting justice for such matters. But right now, the industrial court is up and doing, and such matters are resolved at the court. Pronouncements are made by the courts. But employees, even without a deliberate policy, usually prefer to adopt the ADR option of not wanting matters to leave the office premises, the additional premises. They want to resolve it in-house.
All right, thank you so much.
Of course, but of course, a lot will depend again on the, if it's sexual harassment, you don't expect the victim to want to resolve it via ADR. A lot of cases now dealing with sexual harassment at the workplace. I went to the industrial court, and the court has made definite pronouncements on such matters. For such matters, of course, I will encourage the person who has been harassed to do the appropriate thing. Yes, and we go to court.
Yeah. Okay. Thank you. In your experience, who contacts mediation services? Employee, employer, trade union representatives. Sorry.
Well, right now we have the ADR Center, which is part of National Industrial Courts, and there are two approaches. People could walk into the center to resolve their matters, other matters mediated upon, which is always rare. And people could also be referred to the center by the judge before whom a matter is. But I had done some work on that, and what I found out was that yes, the judge may say this matter you can resolve out of court. Why don't you go and attempt to resolve it at the ADR Center? Inevitably, I have found out from my studies that the client might be willing, the litigant might be willing, but sometimes it's their lawyers. The lawyers who do not encourage them, for reasons I mentioned earlier. Because sometimes the lawyer is afraid that if it's resolved via ADR, it doesn't get its full fees, its complete fees. And so he doesn't encourage the litigant to adopt the ADR option. However, you also have cases where, yes, lawyers who are well-versed in ADR, that's one of the things we do in my office. We try to advise you on the options available to you and advise you to try the ADR method first, option first, before thinking about going to litigation. But unlike the client where you are, of course, you know that sometimes when you adopt that approach, you find the client who thinks that maybe you don't know what to do, or you are afraid of going to court, or you just don't have the lever. So a lot depends on how you assess the client before you. It depends on the advice you give. But basically, we give you that advice. It's your choice to make. And when you insist that you want to go to court, then we don't have an option. So I think that, so for the industrial courts, of course, the services are conducted by trained officials at the ADR center. Of course, you also have what I call the informal ADR, which we have in workplaces. Sometimes you don't have to go to the court. Within the organization there, most organizations in the handbook have provisions for resolving certain disputes via sometimes the human resource department, depending on the kind of matter at stake. So it all depends. And of course, like I said earlier on, there are times, especially where a lot of workers are involved, the trade union steps in to protect the interests of its members. In my state, in my state at the moment, we have a matter we're trying to resolve out of court. We had a committee, what we call committee of the State Executive Council, comprising the Attorney General, the Special Advisor on Legal, myself, and 2 or 3 other lawyers who are part of the Executive Council. And we are negotiating with the trade union, negotiating with the state on behalf of its members. And so we're having some mediation and to resolve the dispute out of court. And the trade union is the one negotiating on behalf of its members. And we make substantial progress.
Oh, wow. Now, when you said my state, is it which of them are you referring to? Is it Anambra or Enugu State?
Anambra State.
Anambra, okay. All right, thank you. So what are the motivations of employers, whether trade unions are generally supportive of mediation processes?
I believe everyone is. Trade unions, employers are supportive. I mean, for one obvious reason, no one wants an industrial unrest. Of course, we know how that affects the workplace. I mean, we saw what even happened with the ASU strike and how it has affected the universities and students. So by and large, employers as well as trade unions are all supportive of the mediation process or the use of ADR to resolve disputes. Again, that's why if you look at the Trade Disputes Act, Section 20, it tells you the steps you have to take before you eventually you decide to go to arbitration, if you're required to arbitration by the minister, or even as in this case, some matters, before you even get to the industrial courts. So the law recognizes also that it's important that you make every attempt possible, every attempt at resolution of the disputes via ADR. The trade unions, from my experience, always prefer ADR than going to litigation. Because litigation can be very, very, very long stretched. And so long as litigation is there, it takes quite a long time to get a final resolution. And so as much as possible, they will prefer to resolve it via ADR.
Okay. All right, thank you. Sorry, why does the Trade Disputes Act prohibit disputing parties from bringing their grievances directly before any arbitral body without consulting with the Minister of Trade and Industry?
Well, you know, the Trade Disputes Act is a relic of the old, it's been there since the 1970s, I think. But I do know that no, there's a process ongoing now to amend the Trade Disputes Act. We have what we call the Labor Standards Bill. and I was part of the team that worked on that bill with the Agenda for Congress. I think the aim is to have every labor-related legislation in one act.
Yeah.
I know a lot of work was done on that. I don't know if it's gone to the National Assembly, but I know the Minister of Labour was particularly keen on seeing that the bill goes to the National Assembly. So when the amendment comes out, many of these provisions, which were not, many of the provisions came into existence when we were under military rule.
Yeah.
And many of the provisions, of course, would not be found in the new acts whenever it comes into existence.
Yes,
and that's why, because that is why the IAP as a body also sometimes has been accused of not having sufficient independence. And that's why you see the trade unions refuse to go to the IAP sometimes, to rather go straight to the industrial courts to ventilate their grievances, which they are entitled to do. Except matters that have to be.
Sorry, what's the IAP is the arbitration panel or something? Can you?
Yeah. Industrial
Okay.
arbitration panel.
Okay. Yeah. Okay.
So I think that this provision flowed from the kind of government we had at the time when it came into existence. But when the new amendment comes up, many of these things, not just these, there are several other provisions that I know will not see the light of the day.
Okay.
That's also why you find out that the minister is quite powerful, and so he has the power. If you look at the IAP, that one has to go to him. He has to decide before it's published, etc. That's not the physical essence of arbitration. But once the amendments are out, all those provisions wouldn't be there anymore in the new acts that we're going to have subsequently.
Okay. So because you've answered the next question, but I still have this question that you need to touch on. Do you think parties are under pressure to settle their disputes due to the minister's undue interference or influence in labor disputes?
I think so. When trade unions are involved, of course, you know that whenever trade unions decide to go on strike or declare disputes, the pressure will always be there. No minister, no government want workers to cripple the economy. So naturally, the pressure will always be there to settle as quickly, as amicably as they can. A lot will then depend on the ability of the trade unions to negotiate effectively with the employers or with the federal government, as the case may be, in respect of the matters that are in dispute. Is the pressure always there? Yeah, I believe so. But of course, you know that once services are shut down, you know the impact it will have on the economy. And I would ask to strike as an example. You saw what went on, all the processes, 8 months. And it's had a long-lasting effect, which will take quite some time to wither off.
Okay. So does it mean that some scholars would argue that that's no longer ADR if people are under pressure to settle their disputes?
I still like ADR.
Yeah, because if it's meant to be a voluntary process, you know.
Yeah, well, yes. I mean, you know, it's meant to be voluntary. It is voluntary, but of course, even you know, even for even when parties decide to explore ADR to resolve a matter rather than go to court, you still have persons by the side who try to encourage them, or sometimes who try to pressurize them into letting go of the matter. Yeah. So, however you look at it, inevitably, you have some form of, it depends on the kind of pressures now. Are there blackmails? Are there threats? How free are they to say we are going into this negotiation without any form of. But I think the Nigerian workers, the Nigerian trade unions are quite strong, and I don't think they capitulate, in my view, that easily to the kind of pressure until they get what they want. Once in a while, yes, they don't get exactly all they need, all they want, and then they bow. Of course, you also remember there's a public opinion.
Yeah.
That will also force them to negotiate. And we saw all that after strike, when eventually the matter went to court, as it were, and the decision was given. Pressure was on us not to appeal.
Yes, sir.
Public pressure from parents. It does happen. And eventually they had to succumb. They didn't want to lose the sympathy of Nigerians.
Yeah. Okay, thank you.
I'm just wondering whether the matter has actually been fully resolved. I hope it doesn't come up again, because there are still a few what I call unanswered questions, which the president of ASU referred to the other day. And but I'm sure, I want to believe that sessions are still ongoing to get all that resolved.
Okay. All right, thank you so very much. So, what do you think are the main motivations of the federal and state governments in encouraging this form of dispute resolution in industrial relations?
I said a few minutes ago, no one wants a disruption in the system.
Yes, sir.
Yeah, but I think that as time goes on, our leaders need to be more sincere and honest. When we're negotiating with trade unions, government at all levels, whether it's the federal government or the state government, needs to be a bit more sincere and honest in dealing with trade organizations, especially where agreements have been made. It would be nice. That's why sometimes when these problems come up. So when negotiations are ongoing, it would be nice not to agree on what is not practicable. That's the pain. If you agree on what is not practicable, tomorrow the problems will come up. Because after a while you realize that you are not in a position to do the obligations. And of course, the other party will say, no, it was voluntarily entered into. And that's where the problem starts. So I think nobody likes a disruption at all.
You're right.
And so whether it's the federal government or state government, I believe they're all supportive of the process. And whether such disputes are resolved via ADR than through litigation.
All right, thank you so much. Okay, I'm looking at the time now. So the trade unions generally supportive of working relationships with lawyers and law firms in settling collective disputes, overpay and working conditions.
Yeah, I would say working relationships, I wouldn't say with lawyers and law firms. I think trade unions prefer to negotiate directly.
Oh, okay.
On behalf of their members. Yeah, the time when the law firms come in or when a lawyer comes in is when, more often than not, when the negotiations break down, and then you want to go to court. Again, they could also be in court and now want to resolve again, go back and attempt settlement out of court again. That's when the lawyer has a role to play. So at that point, he is the one who's conducting the case. Of course, with the permission of his clients, he can then negotiate on behalf of the union with the employer or employer's organization. But that be an issue. The unions usually handle these things internally, and they negotiate with the employers before the issue of going to lawyers arise.
Okay, all right, thank you so much. So, Uncle, what do you think? Why is ADR more prevalent or popular in the developed countries than it is in the developing countries?
Well, I'll say they've been practicing that over the centuries. Of course, we have been practicing it. We do practice ADR customarily.
Yes.
That's why we still say we have customary arbitration in Nigeria. But I think the what I call the formal practice that we have now has been there over the years. I don't think we've done badly in the country as a whole. The awareness has really grown. And I think as time goes on, people will also realize the need and importance not to resolve every matter or every dispute via litigation. Again, that also calls for awareness on the part of the employers.
Yeah.
I do know that in Nigeria at the moment, there are quite a number of societies, organizations. You have the Institute of Arbitrators and Conciliators, you have the Arbitration, NICAP, you have CIBK, Nigerian branch, all are geared towards promoting the use of arbitration and ADR as alternative litigation. And as this awareness grows, I think in the next decade or less than a decade from now, I believe we're going to have more matters, quite a number of matters resolved via ADR. And lawyers will also begin to understand that you actually make more money that way, because when you paid your fees, you have just a short time frame. Within a short time frame, the matter is resolved, and you can move on to other things. And also the public will also understand the need to also pay lawyers. The problem we still have today is that sometimes the public find it difficult, litigating public find it difficult to pay a lawyer who has conducted mediation services on his or her or its behalf. And more often than not, you know, as a society, people feel, what have you really done? You haven't done anything. So why should I pay you X, Y, Z or ABC? But I think as the awareness also grows, the public will understand the need to ensure that lawyers earn their dues. And that way, it will help the practice of ADR grow.
Yeah. Okay. Yes. All right. Thank you so very much. So, final question is what is the way forward for mass advocacy or awareness of the benefits of utilizing ADR?
I think you just made the point. Mass advocacy, we need to, like we do in the universities now. ADR is taught in the universities. Several years ago, many universities are not offering arbitration or ADR courses, but many universities are doing that. Maybe with time to also cascade down to the secondary school, tertiary secondary school level. Yes, where people become aware, because as they become aware, as they grow, they take the message along with them. People also become aware of the importance and need to use ADR to resolve not all, but many kinds of disputes that really shouldn't go to court. So that mass advocacy, that training, it's very important. And I would say there is need to also include the curricula of the universities. I think practically every university in Nigeria now, 5-6 years ago, it wasn't like that, but practically every university in Nigeria now offers arbitration and ADR as a course, one of the elective courses. And by the time we get down to the secondary school level, that will also help to grow the awareness.
Yeah, well, I'm wondering why it's still not compulsory, you know, yet. And even in law school, I don't think they teach it in law school in Nigeria.
I think that they do, but it's not. You know the way law is very vast, and then you have, of course, the compulsory courses which you have to offer. But look at some of those courses from your first year to your final year that you have to offer. There are critical courses you can't afford not to have knowledge about. Perhaps a way out may be to make it compulsory in the sense that, yes, you'll attend classes, but you may not have to write exams. And then have to find ways of ensuring that attendance is compelled.
Yes.
That will be one way. I know there are institutions, universities, I know about 2 or 3 that insist that you have for law students that you have to come for the lectures, even if you're not offering it. So that would be one way out of it. But because of the workload, which I'm sure adding it again to the pricing, It's quite heavy.
Yes,
but I think the interest is growing. For example, in my university, I teach arbitration, and just before I left for this assignment, like I had a class out of a student population of about 200, thereabout. Just about 20 offering arbitration, just 20.
Just 20. Oh.
You know, but again, but you see them, you know what happens when students get to school, they want to do for the A courses.
Yeah.
So I'm more interested, where will I get my A? That course I don't want to mention, where will I get my A?
Very strategic.
So you have just about 20 people offering who say, I really want to know about this, and you come for lectures. So over time, I'm sure it's a gradual process.
Yeah,
we'll get there.
Yeah, fingers crossed. Yeah. Oh, Uncle, thank you so very much for bringing out time out of your busy schedule to come on the show, and also highlighting the intricacies of settling disputes via ADR with Enugu and Anambra State as a case study, So this is like a master class, because this is the first time I'm having someone on the show talking about 2 states in Nigeria. So thank you so very much for throwing more light on this subject matter. And yeah, I hope I would also invite you some other time to talk on other issues bordering workplace conflict, because I have some questions, but I know it's going to take much of your time. So thank you so very much for coming on the show. And to my listeners, thank you so very much for your constant support. Stay tuned, same time for ADR and workplace conflicts, Nigerian Perspective. All right, bye-bye, Uncle. Take care.
Thank you.
Yeah, cheers.